Today we have the pleasure of welcoming Haksoo Ko, the chairperson of South Korea's Personal Information Privacy Protection Commission, the PIPC. Chairperson Ko is an accomplished academic and lawyer and is an expert on both law and economics and data and artificial intelligence. Prior to his appointment to the PIPC in 2022, Chairperson Ko was a professor and the head of the Center for Law and Economics at Seoul National University and served as the president of the Asian Society of Law and Economy. These are just a few of the many prestigious roles that Chairperson Ko has served in. He holds degrees in economics from Seoul National University and a PhD and a JD from Columbia University. He has practiced law in both New York and in Seoul. So it's wonderful to have you here, Chairperson Ko.
Thank you.
And to begin, I wonder if we might discuss the current state of privacy and data protection in South Korea. I thought it would help for our discussion if we started with your overview of how South Korea regulates data privacy, and for also telling us about the role of the Personal Information Protection Commission, which you head.
Okay, thank you for the invitation and thank you for the nice introduction, Paul. It's an honor and privilege to be here and have a chance to talk about what's taking place in Korea in relation to data privacy. Well, just give general overview of what's happening in a few minutes. Historically, there are, I would say, a few milestones. And the first big milestone in Korea, in my view, perhaps took place in 1995. In 1995, the first privacy statute was enacted in Korea. It was only for public sector. So in broadly speaking, it can be compared to in the U.S. Privacy Act of 1974. So in that respect, Korea was behind by 20 years compared to the U.S. in enacting a statute in privacy. But it took some time before the general public figured it's important to protect privacy, not just in public sector, but also private sector. So the next milestone took place in 2011. So in 2011, the General Privacy Act was enacted. It's called Personal Information Protection Act. So that's the year, 2011 was the year when we saw the general or omnibus privacy law enacted, and this law continued to be in existence until today. And this act, for short, PIPA, covers public sector and private sector together. And with this enactment, our commission was established, our Personal Information Protection Commission. But initially, the commission was given only advisory role. So for the next 10 years or so, we were there, but relatively speaking, the role was fairly limited. And then the next big milestone came in 2020. In 2020, PIPA, Personal Information Protection Act, was amended in major part, and well, part of the amendment was the kind of reshuffling or reestablishment of Personal Information Protection Commission. And perhaps most importantly, the Commission now, after 2020 amendment, became fully independent. So it's kind of like general data protection authorities that you can see in many European countries. So now we have we submit our own budget, we hire staff, we make that kind of decisions independently, and more importantly, perhaps in practicality, we now have full authority to conduct investigation and impose fine. So it's been, in that respect, about 3 years since we have been given that kind of full authority. So during the past about 3 years, we have been doing enforcement work vigorously. So during the past few years, we have been having like 500 cases of administrative dispositions. And maybe we'll talk a little bit later on. One of the most noteworthy, or the case that got a lot of media attention, was our case against Google and Meta that we had last fall in September, and a follow-up case against Meta in February of this year. So as an independent data protection authority, we prepare policies and execute them. We publish guidelines. We investigate and sometimes impose sanctions or fines and all other activities that you can generally expect from a data protection authority.
Thank you. And Haksoo, I remember so well meeting with you in Seoul prior to 2020 and our discussion around the PIPC. And you're telling me, well, it's very weak, it only has advisory powers, and then kind of fast forward to 2023, you're running the show, and they changed the law, and you have a lot more power.
And I failed to mention, in 2020, there was a major amendment, and we became fully independent. And this year, on 27 February, we made another major amendment to the statute, and it will become, in major part, in September of this year. And there are a lot of changes that we are making to the statute. So there will be more changes that are forthcoming.
Well, let me ask you about the statute then. And so as I read the statute and I try to situate it vis-a-vis the U.S. and vis-a-vis the EU, one of the things that struck me was how strong its provisions for consent are from the American perspective. For example, the PIPA prohibits bundled consent, quote unquote bundled consent, and requires that consent be informed and specific. I wonder if you'd like to comment on the consent provisions, or perhaps there are other aspects of the PIPA that we should be thinking about and highlighting.
In Korea, consent has been emphasized perhaps much more heavily compared to other countries' laws. In a very simplistic way, the way the Korean law has been structured would be kind of having two-step approach. You consider whether the information that you're considering would fall on the defined definition of personal information. And if the information that you are dealing with falls on the defined term of personal information, then you get consent. So consent has been very, very heavily emphasized. And with the current amendment that I just mentioned, which was made this year, we kind of try to go away from that too much of emphasis on consent and try to have informed consent as much as possible. And in order to move toward that direction, we introduced a new provision for legitimate processing of personal information, which is the information needed for the execution of contract. You wouldn't need to get separate consent. So until now, we had kind of dichotomy of information when you get consent, which is mandatory or necessary information, and the other is kind of optional information. So generally, the idea is for necessary or mandatory information, you don't really need to get consent. On the other hand, if you're going to get optional information, optional personal information, now you need to explain more clearly and have informed consent from that subject. I mean, then perhaps a next question would be how you distinguish between mandatory information and optional information. And now we need to work out the details for that kind of more nuanced differences for to be laid out enforcement decree.
Okay, that's very helpful. And while we're kind of talking about the structure of the law, I have another question, and then we can move on to enforcement. So you mentioned that the PIPA is an omnibus law. And so in the language of information privacy and data protection law, of course, an omnibus law is one statute that governs both the public and private sectors. And that's very standard in the EU and is not something that the US has yet pulled off, at least not at a federal level. And so typically in systems that have omnibus laws, they are bolstered by additional sectoral legislation. And so we see that happening in both Korea and in the EU. So in the EU, we have, of course, the world-famous General Data Protection Regulation, the GDPR. But we also have regulations like the DSA, the DMA, the Data Act, the AI Act, and the Data Governance Act. That's in the EU. In the Korea, there has been a similar trend with, for example, the ICNA being enacted, and then those provisions being integrated into the PIPA. So sectoral laws in Korea being integrated into the omnibus structure. So I wanted to ask you about that and this Korean approach, which to my eyes seems to be a unified, comprehensive regulation incorporating both omnibus and sectoral legislation, as opposed to the EU approach, where there's omnibus legislation and then all kinds of complex add-ons that are being cranked out right now.
Yeah, good point. And well, there are still, say, remnants from the old days in Korea, which is we have this Personal Information Protection Act, but we still have separate law governing financial information, which is generally speaking akin to FCRA in the US. And there is also separate law dealing with location information. So there are still sort of remnants from old days, but as you mentioned, now Korea with this Personal Information Protection Act, it's considered general law or omnibus law, and having omnibus law is often compared to, say, the European approach of GDPR. And one really big question, maybe this could be a dissertation topic of a doctoral student, which is how would you compare? I mean, many observers are saying that the EU GDPR has been sort of exported all around the world, and many countries around the world have been adopting GDPR-style general privacy law, and maybe Korea is counted among these countries. And well, there are, in terms of statutory structure, a lot of resemblances. There are provisions that you can easily find in both in the Korean law and also in the EU law. The real question would be that kind of statutory similarity. Does that also mean substantive similarity or similarity in practice? So in Korea, the reaction has been very different depending on who you ask. Some people say now we introduce something similar to the GDPR. Some other would say we introduced some part of the GDPR, but not too much. Some have a very cynical view, even saying that we imported some aspects of GDPR in appearance only, or even as a pretext to do something else. So there has been whole gamut of reactions. With this law, we now can protect privacy fully, or some other reaction would be this law has been there to facilitate businesses utilizing personal data. So there has been so diverse views about the Korean legal landscape in this area.
Thank you so much. So you mentioned enforcement, and why don't we take that up? So the PIPC, your agency, reports directly to the directly elected president of South Korea. And as you noted, although it was first set up as an independent agency in 2011, more recent restructuring of the PIPC has granted it independent authority. So it can now conduct investigations and impose fines. It's an independent government agency at a minister level. It submits budget to the legislature as a separate governmental agency and can be called to give answers to the legislature on a regular basis. So tell us about your enforcement activities and the remarkable sanctions that the PIPC now has at its disposal.
Well, we, do investigation. If there are ways to get reports about violations or alleged violations, or we can do investigation with discretion. So there are various ways that we initiate investigation, and oftentimes before we engage in formal investigation, we do fact-finding missions. And as I mentioned at the outset, we have had, during the past close to 3 years, about 500 administrative dispositions. And we imposed fine, maybe most crucially, late last year, about $70 million US dollars against Meta and Google, and so far in total close to $100 million. And that kind of activities, kind of imposing a diminished fine, initially in itself got newspaper headlines, but nowadays the sentiment has been shifting a little bit. So won't say until last year or the year before, just the fact that we are now doing formal investigation and imposing fine itself was an issue. But nowadays, like last month when we had a case against McDonald's and charged maybe 60,000 US dollars, maybe around that amount. And the headline, one headline said, with massive data breach of a company like this, why this small amount? So general sentiment has been shifting, and that's kind of the atmosphere in Korea.
Let's talk then maybe about Meta in a little bit more detail to the extent that you feel that you can. And so that in 2022, as you've stated, the Commission fined both companies for failing to adequately obtain consent from users. And then in February 2023, as you've alluded to, the PIPC sanctioned Meta again for having violated the PIPA, alleging that it had collected third-party behavioral information off non-Meta apps and websites, and that Meta had refused service to customers who did not agree to their third-party data collection practices. At the time, you stated that this enforcement action would hopefully, quote, serve as an opportunity for Meta to review and modify its business its business model, rather, in a manner that would comply with South Korean law and respect customers' right to self-determination. So I wonder if you have any thoughts about the changes to the business models that you hope to see, and if you expect more enforcement actions as a result of the amendments to the PIPA.
Yeah, our case against Google and Meta got a lot of media attention. The case that we had last September, it was inherently about, the two companies' similar business practices, which is getting users' behavioral data through various third-party sources. So, any user browsing the web or using a mobile app, through that process, they generate various behavioral data. And Google and Meta, obviously, they collect so much of behavioral data from all different websites and apps. And our finding was that, doing that kind of data collection, they didn't really inform and fail to get consent from data subject, and that violated consent-related provisions under Korean law. Obviously, they were not happy with that, and their position, in a nutshell, was, these third-party websites and app services, the service providers or web managers, these are the ones which should get consent, not Meta or not Google. That has been their common position. And we imposed fine, and I recall last month they challenged our decision and filed the lawsuit. So the lawsuit now has started recently, and the case against Meta of February this year is slightly different from this. The Meta, they sometime during, as I recall, around June of last year, they began showing pop-up window to users. And the pop-up window said, unless you consent to this within a month or so, you wouldn't be able to use our services any longer. And the consent there included collecting all the data from third-party sources. And using Meta service, Facebook, Instagram, for users, they use these services to engage in communication with their friends and others, and exchange messages and that kind of things. And the behavioral data Meta is collecting through various sources are so vast and far exceeds what's really needed to provide the social media service. So in that respect, we found Meta violated data minimization principle and related provisions under Korean law. So we imposed a bit of fine and also ordered corrective order to correct that business practice. So these two cases, one mainly about getting informed consent, and the other mainly about data minimization principles. So what we expect from them is to comply with this kind of principles.
Thank you. So I want to ask you some questions about cooperation with the EU, and then we can open it to questions from the audience. So first of all, the European Union has granted Korea a much coveted positive adequacy decision. That was in December of 2021, and that allows Korea and the EU to exchange personal information without any further legal requirements. And I know you were involved in that prospect of the finding an adequacy decision. And I also know that during it, you refused to give me any information about it every time we talked about it, since you were involved in it, which only made me respect you more. So now South Korea has that adequacy decision. And in your inaugural address, after you were appointed to the PIPC, you stated that one of your priorities would be to establish deeper ties with other data protection and privacy organizations across the globe. So I wanted to hear a bit about the relations with the PIPC and EU data protection regulators, as well as with the rest of the world, including the United States.
Yeah, well, this day, international aspect of data protection or anything related to data is really crucial. And getting adequacy from European Commission was, considered to be significant, and it has some practical meaning, but also has a symbolic meaning. Symbolic meaning being that now Korea's law satisfied certain kind of international standard, maybe high standard, and that was that was considered to be crucial. And in fact, after the GDPR went into effect, there are only a handful of countries which got adequacy assessment. Japan got one, and Korea, and also after Brexit, the UK got. So only 3 countries got adequacy assessment. And the adequacy assessment process itself is fairly cumbersome. It takes a lot of time. And there well, some cynical view about the assessment, adequacy assessment process is it is so it consumes so many resources and takes so much time. So it perhaps would not be practicable to have assessment on individual country level and grant a decision for so many countries. And about international coordination and collaboration, the issue that I see is this. For example, I get questions about ChatGPT all the time during the past couple of weeks, whether or what we should be doing with this. One kind of recent phenomenon is whatever there's new service, it becomes suddenly global service, and there are issues similarly arising in all over the countries. And the case we had against Meta or Google, there are similar cases in the U.S., in European countries, and once you look at the details, there are some differences, but also there are many similarities. So in that respect, we feel there's a need to collaborate and exchange information and ideas. And at the same time, when I go meet with privacy regulators in other countries, in particular around Asia, the enforcement activities and accumulated know-how, there are a lot. relatively speaking, in the US and in European countries. But once you begin looking at other countries outside of the US and EU, there are very few which has that kind of enforcement know-how and experiences. And Korea is perhaps in that respect among very few. And I, oftentimes get, informal requests of, whether there would be a way to learn how handle cases, how to do investigations. So there's, nowadays, maybe almost all the countries around the world have some statute, maybe in just writing, but not, without enforcement capabilities. So there is institution building needed, and also technical and enforcement capabilities to be built. And then there's a lot of room for further international collaboration.
Thank you so much. Let's see if we have any questions. Please just raise your hand. Oh, we do?
Hi. Is this work? So I read the news this morning saying that South Korea is going to pass PIPA amendments to grant individuals a right to refuse automated decision making, which is highly similar to the GDPR's rights regarding automated decision making. So I'm curious to know about South Korea's current position in terms of regulating AI. Is it likely that the government will consider following the EU's path to regulate AI through an AI Act-like regulations? I'm curious about your thoughts.
So the question, I believe, was about regulation of AI, and we had actually discussed that beforehand in some amendments to the PIPA concerning that.
Yeah, I think you're talking about current amendment, and in there we introduced the notion of automated decision making, and the data subject would be given the right to reject automated decision making. And even if data subjects are subject to automated decision making, they would be given right to demand explanation. So as you alluded, it's about artificial intelligence and artificial intelligence getting into our daily lives. So we had a debate during the legislation process whether having that provision makes sense or not. Some people really didn't feel comfortable having that provision included, and even if that provision is included, and as it currently stands, whether that's fine. Actually, the real issue would be specifically in what kind of situation the data subject would be given the right to reject that kind of decision making, and also if there's a right to be the right to demand explanation is exercised, what kind of explanation should be given to data subject. And we now in the process of preparing enforcement decree, and in the enforcement decree there will be more details to be included. Generally speaking, in principle, the right to reject automated decision making is when the decision would have significant impact on data subject, and then if the right to explanation is exercised, basically the explanation perhaps wouldn't be, say, technical explanation. For example, how the algorithm would work to be shown to like engineers. Rather, it needs to be for the general public to understand. So that would be the kind of general principle or general direction, but we now need to prepare details.
Do we have other questions?
Thanks for your time, Chairperson Ko. My question is, so I like that we are getting better laws and regulations regarding how companies and websites collect personal information and get proper consent. I would like to hear more from you about what PIPC currently does to make sure that all the information that have already been collected in the past are properly managed, they're contained safely, deleted properly, and also are accessible by users themselves to make sure they know what's out there in the world?
Yeah, that's a very good question. There are all the time the risk, as you mentioned. After collecting the data, what happens? Whether they, the general principle is to discard the data once the requisite need, purpose has been fulfilled. And the real question is, what if they keep inside the companies or inside whatever after collecting the data, and the kind of data management and oftentimes data provenance. What if the data flows to a third party? That sometimes becomes an issue, and also after collecting the data, maybe person A only should be given access, but oftentimes B or C or some other people are given access. How do you manage internal access control? That kind of issues are sometimes difficult to monitor and ascertain. So what we do in Korea, we have been doing and plan to do more, is depending on, say, a public sector, private sector, we have somewhat slightly different approaches. For public sector, we designated a large information system which handles, for example, citizen registration number system or other systems which handle large amount of sensitive data, and we monitor and give advice as to how they should handle the data. And for the private sector, one thing that we have been doing is, say, we, for example, we go into e-commerce platform or food delivery service. These kind of platform businesses, they handle so much of data, and so many parties are involved. And each industry has different kind of data collection practices and different data flows. So kind of one-size-fits-all approach wouldn't make sense in that kind of environment. So we kind of approached individual industries separately and tried to figure out what kind of data provenance issues are out there, and kind of learn how things work, and then try to come up with co-regulatory scheme under which we coordinate with industry participants and make a coordinated effort so that data can be more, data collection can be more streamlined, and the work can be done in a more transparent manner. And there are some other efforts, but these are some of the important efforts that we are making.
Thank you. I wonder if I could ask a follow-up, since you mentioned this co-regulatory approach, about how the PIPC seeks to promote self-regulation, or as you put it, co-regulation by private industry. I wonder what role you see these public-private partnerships playing in the Commission's work to better protect personal data?
Yeah, so as an example, e-commerce platform, there would be platform, where kind of serving as a marketplace, and there would be consumers, there would be vendors or software vendors out there, merchants, and so many like players in the marketplace, and there are all different kinds of data that can possibly be collected and can be transferred to third parties, and sometimes some parties try to crawl data from another party. Sometimes we found some kind of data was collected through a printer port. So there's that kind of, or some company was sending out data using API, and the specs for the API were determined on an individual company level. So there are all different ways that have been taking place, and some companies just doing their own ways, and some other companies trying to block or bypass. So we try to learn how things have been working out or haven't been working out, and try to streamline the whole process. So we try to gather major players in the marketplace in this segment, and inherently we worked as a coordinator and try to come up with a scheme, basically using API, application programming interface, and how what kind of API, or in what circumstance, what time, and what detail, that kind of things were discussed and determined. So with that, sort of standards were made, and then we monitor, and we plan to give discount if the industry participants later on are found to be in violation of the law, even if they will impose fine, maybe if they have complied with the scheme, they would be given sort of leniency.
Thank you. Do we have additional questions? Oh, we have a hand. We have two hands.
Oh, okay. Hi, I just had a question regarding the ability of data controllers to use or sell.
Could you speak up just a little bit?
Okay. I just had a question about the use of the word pseudonymized data rather than
pseudonymization.
Yeah, because normally when we talk about data controllers being able to sell or make use of statistical inferences of personal data, it has to be anonymized. And I realized that in Korea you use a different word for it, which is, I think, if I look up pseudonymized data, it's usually considered personal data. And so I'm just wondering if there's a difference in the use of the term, and if there's a reason why you use that term as opposed to anonymized data.
Yeah, that's a good question. We introduced the term of pseudonymized data explicitly in the statute when we amended the law in 2020. And the concept of pseudonymization itself basically came from the EU GDPR. Well, there are differences, though. And the GDPR pseudonymization was mentioned as part of safeguard measures that you can deploy. But one similarity is pseudonymized data can be used basically for three purposes under the GDPR and also the Korean law, which is for scientific research purpose, statistical purpose, and historical archiving purpose. And the main interest came out of these three for the first, scientific research purpose. And in Korea, with 2020 amendment, it was slightly different from the approach of the GDPR. And in the Korean approach, once you have pseudonymized your data, then you can use for scientific research purpose. So it's kind of, well, pseudonymized data under the statute still is considered personal information, but sort of subset of personal information. So once it's deemed that you pseudonymize data you have, you can use the data for scientific research purpose. And what we emphasized was, well, for maybe, hopefully, for scientific breakthroughs, you sometimes need to combine two different data sets held by two different entities. So the idea was to pseudonymize the data that you have, well, party one, and the different data sets of party two, they all separately pseudonymized, and then combine the two different data sets and make sure still the combined data sets remain to be pseudonymized, and then used for scientific research purpose. As you can imagine, pseudonymized data, you need to make sure that it doesn't reveal identity, so it does not easily be re-identified. So for individual data sets, you need to go through the evaluation process, and after combining the data, you again do the evaluation process. So the whole process was pretty cumbersome. So it has been used for, well, sometimes, but not very actively. So there are different reactions about this whole scheme. For industry in general, for businesses, the criticism has been that the whole scheme is, too complex, too burdensome, so that it's not really useful. And for some privacy advocates, allowing for the pseudonymized data to be used, they can easily lessen the protection given to data subject. So there have been some mixed reaction.
Thank you. Did we have any more questions?
Hi, thank you so much for coming. I hope this question is not too idealistic or sounds too ridiculous, but as a Korean citizen, if you were to be a proponent of the idea that individual citizens should be compensated for businesses' use of personal information, because I think it's widely known that most businesses can't really be run unless they have access to a lot of personal information, by selling that information or using that information in various ways. And it's been so indispensable to a lot of big companies across the world. So if one were a proponent of the idea that we just normal everyday citizens like yourself should be compensated or have kind of a portion of the pie of the financial kind of success that these businesses have from the personal information that is being used, what would be the easiest way for us to try to get this to happen? And I first had this idea because I think there was, a few years back, there was a proponent of universal basic income who was also arguing that UBI should be a thing because all of our information is being used for the benefit of these really large corporations, and that's obviously one way for the government to directly compensate the citizens. But setting that idea aside, what do you think would be the most realistic approach that we could take as citizens to try to get that to happen, to get our individual personal information's use to kind of trickle down to the citizens?
Yeah, that's a very big question. As we all know, many of the big tech companies they rely on advertisement. So Meta, well over 90% of their revenue comes from advertisement. In the case of Google, I recall about 70%. If they cannot really do targeted advertisement, for these companies, it'll be difficult to maintain their business as they have been doing so far. Then what would be other alternative options for these businesses to maintain and there are other options that have been proposed. Subscription has been one. For instance, if you use ChatGPT, there's an option you pay monthly subscription fee. Whether that's doable in other types of media, that's a big question. And also there have been suggestions about giving some sort of dividend to the data subject which produced the data to be used for platform or other users. But these kind of alternatives are, here and there have been attempts of doing that, but so far it has not been able to gather kind of very general widespread usage. So the coming several years, I guess there will be more trials in exploring other alternatives, but so far no clear winner among alternatives, I think.
Well, thank you so much, Chairperson Ko. That was a wonderful discussion, and I appreciate it very much.
Thank you.